Good evening, everybody. For those of you who might have joined in the last few minutes, my name is Stephen Seeley. I'm with the King County Law Library, and I'm also joined by our lecturer this evening, Carrie Kovacevic. Carrie has been a practicing attorney here in Washington for 10 years at Lakeview Law, and her practice includes estate planning, probate, family law, and civil litigation. And just before we get started, I'm going to go ahead and switch the layout of our room, and I will begin to share my screen. Carrie will be lecturing, and I will be controlling the slides, so you may hear her calling out to me to go ahead and advance the slides. Now, while we have this format open, if you'd like to download the presentation, that is available as a link in the downloads box that's in the area immediately below the screen sharing box. We have a fair bit to cover this evening, so we're going to go ahead and hold questions till the end. So the way that'll work is if you have a question over the course of the lecture, just go ahead and type it into the question and answer box, and we will start running through those list of questions that are waiting for us when we get to the end of the presentation. We also have a very helpful part of the King County Law Library website, which you see here. I'm sharing it on my screen now. Now I'm going to go ahead and I'll post that in the chat for everyone to see. You'll be able to use that link to jump out to some helpful resources. It's going to include the slides for this evening, as well as some very helpful materials from Washington Law Help. That includes a packet. And once it loads, there it is, which gives a brief overview of power of attorney. And this is all information we'll be covering in greater depth this evening, as well as some nice generic power of attorney forms for both finances, healthcare, and a revocation in the event that you choose to revoke a power of attorney you might have made previously. So without any further ado, let me go ahead and pull my slides up and introduce Carrie. Thank you so much.
Well, welcome everyone. I'm excited to see how many people are here this evening. Stephen, if you want to go ahead and slide to the next. So this is our standard disclaimer on the fact that this information and content that's provided does not constitute personalized legal advice. There will be some. All information and content is for general informational purposes only and does not reflect all potentially applicable law. One of the questions a lot of people ask me is, why do I need a power of attorney? And the first thing that comes to my mind is clarity, because my office, I see a lot of people that are coming in and they don't have a power of attorney. They're trying desperately to help someone. And so for me, having this power of attorney is going to provide incredible clarity for the people in your life. And for you, if you're helping someone else, will help clarify it for you as well. So next slide. So there's a lot of information to cover. We're going to start with definitions. What is a power of attorney? The difference between a standard and a durable power of attorney. We've probably heard both. You've probably been confused. What's the difference? We'll talk about limited and special powers of attorney. What does that mean and how would I use them? Why do I need a power of attorney? Well, we're going to talk about decision-making and actions that are available without a power of attorney, and then compare that with what you are able to do with a power of attorney. And finally, we'll talk about mechanics, which will include an effective date, whether you have it effective immediately or sometime in the future, why you would do that. We're going to spend a fair amount of time talking about agents, identifying your primary agent and your alternate, and the pros and cons of using co-agents. We'll also talk about agent authority and duties. And then the true sort of mechanical part of it is signature and verification of that signature so that someone who is accepting that power of attorney and your agent can verify that it's a valid document. And then we'll also talk about termination and revocation of a power of attorney. So a power of attorney is a document that grants authority to an agent to act in the place of the principal. So if you have a power of attorney, you're identifying an agent to act in your place. And a standard power of attorney is going to end when the principal becomes incapacitated. The difference with a durable power of attorney is that it continues in effect after the principal becomes incapacitated. So that's the difference. When somebody says power of attorney, it will mean that document, but whether it's standard or durable will depend upon whether it is in effect after the principal becomes incapacitated. And we'll talk about why you would want that or would not. So a limited or special power of attorney comes into play when there are restrictions on either the scope or the time, or both sometimes. The authority that's granted may be restricted to a particular event, such as selling property. I'm going to give you a limited power of authority to sell my house or my car or my business, or I'm going to give someone the authority to manage a certain business transactions or manage my rental property, one or all. And the restriction on time can be for specific dates this person is authorized, while the principal's out of the country, when I'm in a healthcare facility, or while my child is living elsewhere. I'm granting authority to someone who would normally be a parent. And there's an RCW listed there that you can review on your own. So powers of attorney are governed in the state of Washington by state laws and by case law. And state laws are statutes. Those are enacted by our legislature here in the state of Washington, and they are codified. They are published as the Revised Code of Washington, or short, we say RCW. Case law results from judicial decisions. So someone files a lawsuit, Smith v. Jones, there is a lower court ruling, somebody appeals it, the ruling that occurs at the appellate court or above that is our case law. And we also have a statute here in Washington, the Uniform Power of Attorney Act was effective on January 1st of 2017. It has rather a large scope of responsibilities and powers and duties of the agent under a power of attorney. You'll notice if you research this and go to RCW 11.125 that it also refers to other state laws. And if you click on, can you go advance the slide? Thank you. So if you just do a Google search for RCW 11.125, you'll likely be one of the first results will be this page. And you can, there's many, many more sections that are not showing on this particular slide, but you can click on that and it will show that particular, it will show you that particular statute. So for the next slide, you'll notice that within that statute, there is a reference to other statutes, and those are links. It's a very convenient way to sort of move back and forth and around in the RCWs in general, and particularly in the Power of Attorney Act. So a question that comes up is, if I don't have a durable power of attorney, who makes healthcare decisions if I can't do that? And the answer is, we have a statute in the state of Washington. I've listed it here. It's for informed consent. And these are the people that are authorized by statute to provide informed consent to a healthcare provider for a patient who is not competent to consent. And this is the order of priority. So let's consider a hypothetical where you go to the hospital, you've been in a car accident, you've got family and friends in the waiting room, and someone comes out, a representative of the hospital, and they're going to ask, you know, who is the spouse here? Is there? And so they're looking for the order of priority. So the order of priority is, if you have a guardian, that person is going to, they are going to be making decision. If it's an agent under a durable power of attorney, they are going to be making the decision. The spouse is next, then children, parents, adult brothers and sisters, adult grandchildren, if they are familiar with the patient, And the next slide is then adult nieces and nephews, adult aunts and uncles, and then you get to an adult who has special care and concern for the patient. They're familiar with the patient's personal values, etc. The issue here is people say, well, if I'm out with my boyfriend or girlfriend or partner or whatever, and I get in a car accident, they're the ones that are going to be able to give informed consent. They'll be able to deal with all of that. That's not the case. Because an adult who happens to know you and care about you is nearly the last person on the list. There really isn't anyone lower than that. So that's why having a power of attorney is important, because you want to be able to identify who, in this instance, you would like to be making those decisions for you. So why isn't that RCW enough? Why isn't having that hierarchy of people that can make those decisions? Well, what that statute actually does is it allows a healthcare provider to breach HIPAA, and you're all probably familiar with the Health Insurance Portability and Accountability Act. That is going to give them the ability to give information and get information about the patient's health, and then receive informed consent for procedures. It's very limited to that. It will be about, is this person on any medication? I think they need surgery. I think we need to intubate them, etc. The statute does not grant authority to someone that is the same scope as in the RCW 11.125, which is the power of attorney statute, that you can incorporate into a durable power of attorney for healthcare decisions. It's so much more limited than that. And we'll talk more about what that scope is. So if I'm injured or become ill and I can't make decisions for a period of time, you need to ask yourself these kinds of questions. Who's going to arrange for me to be at the best hospital? What if you are ill, you're in another state, or you're in Washington, but you're in a community that doesn't have great hospitals? I want to go to Seattle Cancer Care Alliance. Is that, who's going to make that decision for me and facilitate that? Who's going to remove my doctor or request a second opinion? And who is going to decide if I should have surgery? Who do I want to make that decision? And who will manage medication? Who's going to decide whether I should be taking one over another kind of medication? And who is going to hire and manage home health care workers? Who's going to select a care facility if I have to go for rehabilitation or long-term care or short-term care? And who's going to monitor the care that I receive there? Who is going to assess my health insurance coverage so that if it comes up for renewal, do I have adequate insurance to cover the medication I'm currently taking, or some of the other things that might be covered? And finally, who is going to make end-of-life decisions? Who's going to decide when I should be removed from life support, etc.? And the answer to that is an agent under a durable power of attorney for healthcare decisions. Those are the people that can make those decisions for you. So if I don't have a durable power of attorney, who makes financial decisions if I cannot? And the answer there is, well, can my spouse? I mean, I'm married. My spouse knows everything about our finances. So the issue in Washington is this is a community property state. Your spouse has authority to manage, sell only half of your community property. So if you need to sell your house and you're both on title, one of you has to be able to sign, and one of you may be incapacitated and unable to do so. With separate property, if it's owned entirely by the spouse that's now ill or incapacitated, your spouse doesn't have any control over that. Again, if you have a power of attorney and grant them that authority, then they do. Can my state registered domestic partner do that? They're in the same boat nearly as a spouse because there are property rights and they may not have the right to manage separate property. Can my partner, girlfriend, or boyfriend, or my parents, can a sibling or a friend do that? Well, the answer in general is no, they are not going to be able to access your financial accounts and take care of your bills for you by being able to write checks, etc. The solution in that event is guardianship. So a family member, friend, even a care facility can file a petition with the Superior Court to appoint a legal guardian for you if you need that level of assistance and you don't have a power of attorney. And there are a number of reasons why you would like to avoid that. One of the most significant is cost. In the Seattle-King County area, guardianship costs between $7,000 and $15,000, and it can go higher, much higher, depending if there is a challenge to who has stepped forward to be the guardian. And the opposite of that is a power of attorney is either free, or depending on if you use an attorney and how complicated it might be, you might pay up to $500 for that. They usually, if an attorney prepares them, between $250 and $400 is probably the most common. Also, control. In a guardianship, a judge is going to control the determinations. In a power of attorney, you're going to control them, as well as the statutes I've referenced. There's also an issue of time. Guardianship can take 2 months or more to establish. A power of attorney can be effective immediately or after a determination of incapacity, but that can move very quickly. And finally, the issue of being a burden on family and friends who have to find $7,000 to $15,000 in cash until they can get access to your money. So there are a lot of reasons why you want to avoid guardianship. Who can be an agent? It can be an individual. They have to be 18 or older. They can be a spouse, a domestic partner, a sibling, a parent, a friend, really anyone. Or it can be an entity, and we call those professional fiduciaries. And if you need a professional fiduciary, you can do a Google search for either fiduciary service provider or guardianship service provider, and you will find the search results will include companies that do this work. Usually they're in a small group of people that provide professional agent or personal representative if it's a will, but they are professional fiduciaries. And we're going to talk about the mechanics next, the effective date, those co-agents, agent authority and duties, the signature verification and termination revocation. So the effective date. You can have it effective immediately. Why would you do that? Well, very often when someone comes in, they may come in as a married couple or just a single older person. If they are at an advanced age or are in declining health, a lot of people come and they say, I have to have surgery, I've been diagnosed, etc. If the surgery is scheduled or they're anticipating surgery or some other medical treatment that may render them incapacitated, if they are either frequently or infrequently involved in high-risk activities like parachuting, mountain climbing, etc. If they're traveling somewhere that is considered dangerous, and there are third world countries, etc., we're all aware of that, and then traveling without consistent access to phone, internet, mail service, etc., where you're a little isolated from being able to contact people and take care of your affairs. There may be some other issues. These are the primary ones where you would want a power of attorney to be effective immediately. So the other option is that it's effective at some time in the future upon your incapacity. And incapacity is defined by statute as an inability of an individual to manage property, business, personal, or healthcare affairs because they have an impairment in the ability to receive and evaluate information or make or communicate decisions, even with the use of technological assistance. And technological assistance can be anything from sign language or writing on a pad or any other type of technological assistance, a board where there are words and they push those words and form sentences, etc. The other incapacity is if you're considered an absentee, and an absentee is you're identified as an absentee if you're outside the county where you normally reside and your whereabouts are not known and can't with reasonable diligence be ascertained. So one of those two situations makes you have incapacity. What if I need help with some things like paying bills, but I can still make decisions? Well, your agent is supposed to act in accordance with the principal's reasonable expectations to the extent actually known by the agent and otherwise in the principal's best interest. And what that means is people are often very concerned when they come to me and they say, I don't want to have a power of attorney because I don't want someone to just come in and take over my life. The state of Washington, the power of attorney statute grants a lot of protections for principals because the agent is required to work with the principal, even if the power of attorney is effective immediately. And that is the point here where you're acting in accordance with the principal's reasonable expectations to the extent actually known. That means you're supposed to try to communicate with them and find out how they feel, what they think, and follow that instruction, unless there is some, because of their inability to understand or reason or receive information that there is an issue with that, then the agent can act without it. But otherwise, they have to act loyally for the principal's benefit, and it includes knowledge of what the principal wants. Who decides when I'm incapacitated? Well, when you have a power of attorney, you identify someone to make that decision. And most often it will be a treating physician. I sometimes will have two physicians if someone is particularly concerned about, well, if I'm in an emergency room or I have a doctor that shows up that doesn't know me, I don't know if I want them to make that decision. I'd like to have two physicians make that decision. The treating physician is going to sign a document, it's usually called a certificate, that indicates that you are disabled or incapacitated and the reason why. And that document will be attached to the power of attorney form. It forms now the full document. If you don't have a power of attorney, a judge is going to determine whether you are incapacitated as a part of that guardianship or mental health proceedings in a superior court setting. So now we're going to talk about the selection of primary and alternate agents and the use of co-agents. So who can be an agent for healthcare decisions? Well, what I can tell you first is that these are the people that can't act as an agent for the principal. And that would be any of your physicians, the physician's employees, or the owners, administrators, or employees in a healthcare facility, like a long-term care facility or rehab facility. And the exception to that is if that person, agent, is also your spouse, a state registered domestic partner, father, mother, or adult child, or brother or sister of the principal. So those are the exceptions, but generally they do not want, especially employees of healthcare facilities, to have the ability to make decisions like that. Why do I need an alternate agent? Okay, when you identify your primary, most people sometimes really struggle with identifying one person, let alone two, but you really need to have an alternate. And the reason is, if you don't identify an alternate, you're going down the guardianship path because there isn't anyone designated to step in the event your first choice is not available. Your primary agent could die. They could just be unwilling at the time they're called to serve. They just don't want to do that. It can be for a variety of reasons. Your relationship with them might have changed. They might be unavailable. They can be out of the country. They could have a significant workload that doesn't allow them to take on anything additional, or their own family issues, sick children, sick parents, etc. Or they themselves could be injured or ill. Can I have two or more people be my co-agents? Can they work independently? And what if they don't agree? This is a huge issue. Most attorneys don't encourage people to identify co-agents. And the biggest reason is that what happens if they don't agree? And this happens a lot where, for example, mom gets sick, she wants to stay in her home, you want to bring in care providers, or she can go to a long-term care facility, and there can be a huge difference in the cost. Your agents may not agree on how your mom's money should be spent or what is the best type of care for her. Then what do? Then you're stalled. Well, the other option then is that if you have co-agents, you should identify a tiebreaker, somebody who's going to make the decision. You can also identify an attorney or a mediator, and that can be something where these two co-agents will together identify someone, or you can identify them. When would I use a professional fiduciary? Most commonly, it's done when there are complex family dynamics where you have multiple children often, or there are multiple people in your life, they don't get along, and it's going to cause so much dissension for a person to identify one person over others. They just say, I'm just going to take it outside the family and identify someone else. The other is when there's a very complex estate. If you own a business or businesses, if you have rental properties, if you have if you own property in another state, a complex estate will often be best managed by someone who is a professional fiduciary. They have a greater breadth of experience in handling different kinds of businesses. And we often recommend to people, there can usually often be a combination of complex family dynamics with a complex, also high asset estate, because people are crowding in to try to gain control sometimes. And the other time is when there's just no other option. Some people come to me in their 90s, they're no longer married, their children may not be available, they don't have any, their friends have all passed on. So that can just literally be there's no other option but to have a professional fiduciary named. Who should I pick as an agent? I spend a lot of time talking to my clients about this because they frequently initially identify one person. It's often a child who is trying to control them or wants to control them. That may be good or bad. It just depends. But the person has to be someone that you trust, and you really should consider criminal activity and drug and alcohol use that occurred in the past and currently. Not a great idea to identify someone who has significant drug or alcohol problems. They tend to be very, they're not usually careful with money, and you don't want them to have access, unfettered access to your finances in that event. They have to be capable of collecting a lot of documents and information. They may need to go through everything in your house and figure out what you own and what you have, the status of your mortgage, etc. They have to be willing to meet deadlines. These may be imposed by the healthcare facility. They can be imposed by a CPA in order to do your taxes. They should be able to consult with experts like your physicians, nurses, your financial advisor, an attorney, and not be intimidated. What's going to happen frequently is people step into this and they just assume everyone that's involved is competent, and sometimes that's not the case, and they need to be able to ask questions and push people a little bit to get to the bottom line. And also they have to be able to make decisions and complete those projects, and also monitor other people's work, because they can delegate work, but they need to be able to keep track of it and make sure that people are on task. Okay, I heard that I have to name my spouse as the agent. Is that true? No, it is not true. And what I have found is that everyone usually there are people that can do both. They do a great job with finances, and they also do a good job with medical. But you'll also see that there are people who have definite strengths. And if your spouse is really good doing financial things, but blood and bandages makes them really upset and they can't deal with it, that is not the person you want to identify as your agent for healthcare. The same person does not need to make healthcare and financial decisions. You can identify other people, even if one of them is your spouse and you've named someone else. Does the agent have to live in my town? No, but it can be very helpful, particularly if they are monitoring or managing your healthcare. If they have to do a lot with your home, it's a lot easier if they live in your town. It's not required. They can delegate and hire people in your town to do things. However, that is a drain on your estate. So it depends on how much money you have in your estate. What if I don't know anyone who is capable of managing my investments? Not uncommon. If you have investments and you are, identifying an agent, the agent is responsible to do things, but they can delegate. And I always recommend, if there is a fairly large or even a small investment portfolio, that they employ a financial manager to make the decisions or to give them advice about making decisions. Then you have a fiduciary duty. If you are not capable, you identify someone who you believe is. And if they make a mistake, it's on them, not you. So you're not held responsible if they buy stock and it tanks, or they sell stock and it suddenly goes crazy. You are using that expert and using their opinion. Okay, this is a really common question, and I'm working with a case right now. My dad is having problems with memory. Can he sign a power of attorney or healthcare decisions or financial decisions? This is complicated, and many people who contact me are calling because their parent is having issues. So the primary thing to remember is at the time of signing a power of attorney, the person must understand the benefits, risks, and effect of signing that document. Many people who have dementia, you've heard of sundowner. That's when usually later in the day, people who have dementia start to decline more rapidly. They get more confused. They may be very sharp in the morning. So the fact that they have not consistent cognition or consistent memory is not necessarily a bar to signing a power of attorney. However, it can cause problems if somebody wants to challenge whether that person was truly competent. So I would recommend, if you're in that situation, to have a third party, an attorney, make that decision. It can be very dicey if you're not certain if they really understand the document. And again, it's at the time of signing. So now we're going to talk about agent authority and duties. So in a standard versus durable power of attorney, the text that must be included in your power of attorney, if you want your agent to act when you are incapacitated, is it has to contain this language: this power of attorney shall not be affected by disability of the principal, or this power of attorney shall become effective upon the disability of the principal, or similar words. And that's the reference to the state law for that. The power of attorney document has to state that it is a power of attorney. And the Uniform Power of Attorney Act provides numerous grants of general authority. I would recommend that you read them. Most people would agree that they would want someone to do all those things, and the RCW range is there in that paragraph, 0.260 to 4.410. But you can restrict the grant of authority that is in those statutes. So you may want to consult an attorney in that event, or if you don't understand the language, it can be a bit dense. But that general authority allows your agent to do many things. And if you want to read what those are, you can look at those statutes. So these are examples of general authority. Your agent can demand and obtain relief or money or another thing of value. If somebody has your car, they can demand that it be returned to you. They can sign documents, enter into contracts, rescind, cancel, terminate, etc., modify a contract. They're acting in your place in these events. They can initiate participate in, submit to alternative dispute resolution, intervene in litigation, etc., settle a claim existing in favor of or against the principal. That's the statute. However, there is also case law that states a person's right to practice law pro se may not be transferred to another person through a power of attorney. What does that mean? Well, it appears to mean that you would have to use an attorney in order to initiate or participate in a lawsuit. There seems to be a little bit of conflict in the Uniform Power of Attorney Act and this particular case law, and there's other case law following this. In that instance, you should probably consult with an attorney and just confirm what your rights are with regard to that. They can also engage, compensate, and discharge an attorney, accountant, any other experts. They can communicate with any representative or employee of a government or governmental subdivision, an agency. This is frequently the case when you are, if you're the person that you're helping needs to be on Medicaid, you're going to be talking to people at DSHS and working with Medicaid financial workers. You can access communications that are intended for and communicate on behalf of the principal, so by mail, by email, etc. And you can basically do any lawful act with respect to the subject and all property relating to the subject. There is a requirement that there is certain language that has to be in the power of attorney in order for you to grant authority to the agent. And the first and most important is to make healthcare decisions. I have had a situation where someone came to me, their parent had signed a power of attorney. It doesn't say anything about healthcare decisions. It's only financial. They thought it covered everything. It doesn't. You have to specifically give them the right to alter your estate plan. You have to indicate that they are allowed to do certain things with your retirement benefits and or annuities. They have to, if you want them to make gifts, to change a beneficiary designation. That can be on life insurance or bank accounts or other investment accounts. Delegate some of the authority granted. So if you don't want your agent to, if you want your agent to be able to delegate to people, then you have to give them the right to delegate. And then to create, amend, or revoke a community property agreement. That has to be a specific grant, even though earlier it said that you can enter into contracts. This one in particular, you must have specific authority to complete that. So with regard to retirement benefits, and this has come up fairly recently where people are trying to access retirement benefits as an agent, unless the power of attorney otherwise provides, language in a power of attorney granting general authority with respect to retirement plans authorizes the agent to do these things. If you don't want that, then you need to remove that right. So it's very important when you're looking at, some people think, well, this is a really simple document, but you may have assets, there may be circumstances where you want to restrict specific rights that would normally be granted to your agent. Now we'll talk about agent duties. So the statute 11.125.140 indicates that an agent is supposed to act in accordance with the principal's reasonable expectations to the extent actually known by the agent and otherwise in the principal's best interest. There is a lot of litigation that occurs when agents do not act in accordance with principal's reasonable expectations or in their best interest. So it's a really important thing to consider. They have to act in good faith, which is honest. They have to act within the scope of the authority granted. If they go outside of it, they will be subject to lawsuit. Act loyally for the principal's benefit. They should not do anything that creates a conflict of interest that impairs the agent's ability to act impartially in the principal's best interest. That might most likely happen when they take money and combine it with some of theirs and then buy property. If they have to act with care, competence, and diligence ordinarily exercised by agents in similar circumstances, that's the bar that you would be judged against. Keep a record of all receipts, disbursements, and transactions made on behalf of the principal. This is so critical. Frequently, I have people coming in, they've used some of their money to assist the person that they're the agent for. They've bought things, but they have no receipts. Keep everything, every receipt, every invoice. Anytime you spend that money, you may have to account for it in court, and you do not want to be lacking on receipts, because that is one of the biggest problems that get people into trouble when they're an agent. The agent also has to cooperate with the other person that has authority to make healthcare decisions. So they're supposed to work together. So the healthcare agent is going to say, I think this person needs to go to Shoreline Rehab. And it will be up to the financial agent, if they're not the same person, to make sure that Shoreline Rehab receives whatever funds they're supposed to receive and other documentation that may not be within the control of the healthcare agent. They have to attempt to preserve the principal's estate plan to the extent actually known by the agent. And I would highly recommend that you review the statute for the complete text so that you can understand what your agent is allowed to do. Signature and verification. This is what makes it a valid document. So by state law, your signature can be either acknowledged by a notary public or attested to by 2 or more witnesses. So this is the statute. And the competent witnesses cannot be home health care providers, a provider at an adult family home or long-term care facility where the principal resides, and who are unrelated to the principal. They have to be unrelated by, if they're related by blood, marriage, or state-registered domestic partnership. So they have to be unrelated. Which is better, having my signature notarized or witnessed? This state law indicates that a signature on a power of attorney is presumed to be genuine if the principal acknowledges the signature before a notary public. Why is that important? One of the biggest issues is who signed this document? And if it doesn't match other signatures, if it's signed before a notary public, anyone who's had their signature notarized know that you have to provide documentation of who you are. Usually photo ID is required. So when that notary signs that it was you who appeared before them, it is presumed to be genuine. So there will be no issue. If it's signed before witnesses, it causes more problems potentially because they would have to track down the witnesses and confirm that they were actually there. Anecdotally, most banks, this is kind of key because this happens a lot. Most banks and other financial entities are going to prefer that your signature is notarized, not witnessed. They are much more accustomed to looking at power of attorney that has been notarized. Even though the state law allows it to be witnessed, the real world application of that is that they will often reject them, and it's not worth the hassle. Go ahead and have it notarized. My mom wants me to be her agent. Why can't I witness her signature? She trusts me. Well, again, the Uniform Power of Attorney Act requires either a notary or a disinterested witness for execution on a power of attorney. And that is to help ensure that the principal is not subject to undue influence or duress. There can be a presumption that if someone is going to benefit potentially from the power of attorney, that they may have put you under undue influence. And you want to avoid that. Question: can I make changes to my power of attorney by crossing out something or handwriting in an edit. I see this frequently. It happens on wills as well. I don't want my sister to receive anything. I'm crossing out her name. I'm going to add other people in. The same thing is true with a power of attorney. It can invalidate the entire document, and you don't want that. So revise the power of attorney properly by having it typewritten, and then re-sign it before a notary to avoid any confusion or invalidation. Now we'll talk about termination and revocation. There is a statute that the authority that's conferred to your agent terminates upon the incapacity of the principal unless you've stated that it's not affecting, that the power of attorney shall not be affected by the disability. It will terminate automatically unless it has that language in there. A power of attorney also terminates when the principal dies. People frequently think that because they're an agent, and they may also be identified as the personal representative under a will, that they can just keep doing things with the finances, etc. Not true. The minute the principal dies, until the will has been verified or you have been appointed and installed as the administrator of the estate, no one is authorized to work on behalf of in an agent status. The power of attorney terminates when the principal becomes incapacitated. If the power of attorney is not durable, doesn't state that. It terminates when the principal revokes it, or there's a language in there that provides that it terminates on a particular date. When the purpose of the power of attorney is accomplished, when you think about that date frame that we talked about earlier, or while I'm out of the country, when the purpose is accomplished, it also terminates. Or the principal revokes it, the agent's authority becomes incapacitated or resigns, and the power of attorney does not provide for another agent to act under the power of attorney. Again, it just becomes a dead document, which is why you want to have an alternate identified. The agent's authority terminates when the principal revokes the authority, when the agent dies, becomes incapacitated, or resigns. An action is filed for the dissolution or annulment of the agent's marriage to the principal, if it's your spouse, or their legal separation, or an action is filed for dissolution or annulment of the agent's state-registered domestic partnership with the principal, or for their legal separation. So obviously, if you and your spouse are separated and then you have you become incapacitated, but you have a power of attorney, that does not continue, it terminates. The power of attorney itself just indicates a date when it terminates. How do I revoke a power of attorney? Well, you complete a notice of revocation. There's a form that Stephen mentioned earlier. You're going to date and sign it before a notary public, and you provide that notice to your agent. And it's a great idea to also provide a copy of that notice of revocation to your medical providers, your financial manager, utility providers, any place that might have the old power of attorney document that you want to ensure that that person is no longer able to act on your behalf by making sure that notice of revocation is provided. Can I just cross out and put in someone else's name as my agent on the power of attorney document to modify it? Again, making handwritten edits can invalidate the power of attorney. It's much better to revise the original document, re-sign, and then have your signature properly notarized. So the key points for this presentation, review that RCW, the statutes that I mentioned earlier for specific descriptions on the scope of the agent's authority. And if there's something in there that you don't want, then you want to be able to indicate that in the power of attorney. Your power of attorney can modify the general authority referenced. You have that ability. Most people don't, but some people do. If there may be something specific in that general scope that you don't want them to be able to do for you. Your power of attorney must identify some language very specifically for certain authority that we've talked about. And the person executing it has to sign before either a notary public, which I highly recommend, or two witnesses. A power of attorney validly executed in this state is valid in another state. And a power of attorney executed in another state is also valid in Washington. A photocopy or electronically transmitted copy of the original has the same effect as the original. There are some exceptions, but take a look at that RCW that's referenced. I frequently, if you have only one original, you do not want to give your original away no matter what people say. Don't let them take your original. You need to have that. Oftentimes they will say, we'll take a copy, but we want to see the original. They want to see that it's an original signature. Unless the power of attorney states otherwise, the agent is entitled to reimbursement of expenses and to reasonable compensation. Reasonable compensation is something that an attorney will probably know about because there is litigation often about whether an agent was overcompensated. And this happens frequently after someone dies and their will is being probated, and they look at what the agent was what kind of compensation they received. So reimbursement of expenses means your agent has gone to the store and bought something for you, and they are able to be reimbursed. Reasonable compensation for a power of attorney, an agent under a power of attorney, is between $30 and $60 an hour. Higher amounts usually have someone who has, say, is a CPA or has other advanced education that makes their time more valuable. A person who refuses to accept a notarized power of attorney is subject to liability for attorney's fees and costs. If you are forced to bring a lawsuit in order to have someone accept a valid power of attorney, you can get your attorney's fees and costs reimbursed. Hopefully the funds that are used would be the principal's funds and they would be reimbursed. Finally, I can't stress this enough, to select your agents very carefully. Think about who you want to make those decisions. And I know it's hard that people get anxious about not wanting to hurt anyone's feelings, but it's important that you identify the people that you believe would be able to accomplish all of the responsibilities that they are given. And then finally, do consult with an attorney. You can make an appointment and run language by them, ask their opinion, and you don't have to spend a lot of money to have that kind of clarity. So you need a power of attorney for clarity so that everyone knows exactly what you want, for control because you're going to be making the decision. It's completely confidential if you go through guardianship. It's a public record. Your situation can be found out by a lot of people. It's not confidential, and customizable. You can do a lot with that document and make it exactly what you want. Give your agent exactly the responsibilities that you want them to have. And it's great for cost management. It is much less expensive to have a power of attorney as opposed to having to go through guardianship proceedings. Questions?
So what I'm going to do at this point is, if anyone has a question they'd like to ask, go ahead and type it in the question and answer box now. And while you're typing, I'm going to go ahead and do a run through. This is the Law Library's website, and we have a page that deals with kind of the basics of power of attorney, so a bit of what we've covered here. It has the slides, as well as some additional reading, and it has the links out to what I was showing you earlier, that kind of the boilerplate documents, the kind of generic forms for power of attorney. And that packet lives here on Washington Law Help, and you just click this item here, and it gives you a quick overview of sort of the things that we've talked about, as well as just kind of fill in the blanks, some very standard forms for a financial and for a healthcare power of attorney, as well as the form to revoke. The address for this is kcll.org/POA-basics. Now I'm going to get started on the questions here. So the first one is, I've never engaged a lawyer before. Does the law library have resources on what I should know going into a meeting with an attorney to go over my power of attorney and other important things to ask? So speaking from the law library side of things, and then I'll pass it off to Carrie, we don't recommend any one lawyer over another, just because if we recommend one over another, the rest are going to show up and ask why we didn't recommend them. So generally what we'll do is we'll refer people to the King County Bar Association. It has a service, they do charge a fee, but they play matchmaker with people and attorneys. So you let them know what the issue is and they give a list and kind of set you up with various attorneys until you find one you like. But from the attorney's perspective of things that clients should ask or what to expect when you're trying to hire a lawyer, I'll go ahead and pass that part of the question off to Carrie.
I think probably the most important thing if you're trying to find an attorney and you don't know is to talk to your friends and family and ask them if they have ever worked with an attorney, and even go outside the scope of just immediate, is, neighbors, etc. And if they say, yeah, well, we had a great attorney, ask them why they thought they were a great attorney. That would be the first thing. The second is you can find attorneys by going to the WSBA website, which I think is unfortunately down right now, but there's a directory on there, wsba.org, and you can identify if you're looking for an attorney by city and also by area of practice. Now, you're going to get a lot of hits. From there, I think select, you can click on their websites, you can kind of get an idea of who they are. Some attorneys will post their fees on their website. As far as being prepared for the meeting, I would recommend that you do take a look at some of the statutes I referenced in this webinar and have kind of a bullet list of questions that you want to ask about. If you have a concern about agent, if you're worried about a parent and the kinds of situations you're finding yourself in with them, whether they have early onset dementia or they've been diagnosed with Alzheimer's, all those things, I would make a list and then understand that what most attorneys like to do is teach. I really enjoy that part of my job, and most attorneys do. They like being the person that answers questions. And our job is to listen carefully to clients, find out what their concerns are, and then craft documents and answer those questions so that you are walking away with a document that you feel really comfortable with and that's going to accomplish what you want. I understand it's difficult. The other option is you can call the King County Bar Association lawyer referral. You're going to be, they only take attorneys into the referral service who have a certain number of years of experience. So they have pre-vetted them for the time and also for any, I think, bar complaints as well. That might be a little easier to winnow down the number of people who have sufficient experience. You want someone who has enough experience drafting these documents, who is familiar with the Uniform Power of Attorney Act. I think it's critical that someone has at least 5 years of experience. It's not impossible to do a great job with less, but if you're really trying to feel confident about it, I would recommend working with someone not directly out of law school. It doesn't mean they can't do a great job, but it's probably better if you work with someone who has a little more experience.
All right, and sort of in the same vein of that question, the next one is if someone were to create a power of attorney from the forms that were just shown, so those Washington Law Help forms, and they have an attorney review it, kind of what would you estimate the cost might be to do a quick review of the pattern forms there?
I would anticipate, I'm going to tell you very honestly that most attorneys would probably not use that form. They probably have their own form that they feel really comfortable with because they have had experience with it being accepted and not have a problem. What happens when you work with a lot of attorneys that do estate planning, and this type of document falls in that category, is that you get a lot of real world application of those documents and you find out what the snags are, particularly with banks. They will not accept a power of attorney because it doesn't contain specific language about this or that. If somebody was just going to confirm that what you need is reflected in that document, I would expect most attorneys would be able to do that for between, I don't know, $100 to $300, but I would think most of them would probably, at that amount, you might as well have them use their form, because it would probably be more inclusive of, all the language that we know works really well. I think the biggest problems that people have with powers of attorney are banks. I hear it over and over. They won't accept it. I can't get into this account. I can get into the savings account, but they won't let me get into this account. It's very strange, but the banks are some of the most difficult people to deal with. And then secondarily, other financial institutions, often, people who are working, say, with Charles Schwab or some of the financial management companies, not to identify them specifically, it's that they have a lot of safeguards in place to make sure that that power of attorney is valid. So they're going to spend time. Anecdotally, it can take up to 2 weeks for that power of attorney to be reviewed by someone's legal department. What I call the big box banks, they have their legal departments on the East Coast. And so they're going to scan and send your power of attorney off to the East Coast, and it can take up to 2 weeks for someone there to review it and approve it. It used to be that the bank managers locally would be able to determine whether that was a valid power of attorney. There's been so much litigation with invalid powers of attorney, fraudulent powers of attorney, that they've removed that ability of bank managers to make those decisions, and it all goes to a central legal department. And unfortunately, the big banks don't have legal departments on the West Coast. So they're 2 to 3 hours ahead, depending on where they are. And it can take a very long time for them to make decisions.
And that wraps up our Q&A. So just one last time, the web address for that page, the page that's on your screen now with the extra info, is kcll.org/POA-basics. So thank you so much for your time, everybody, and thank you for being here with us, Carrie.
Thank you. I really enjoyed it, and I'm glad so many people tuned in. It's an important issue, and I hope everybody can get documents that will work for them.